Welcome to Product AMA, your daily online Ask Me Anything. We started Product AMA to give those passionate or curious about product management a daily break, something to look forward to.
So today our topic is about intellectual property law and product management. And joining us to explore this topic is Anil Bhole, who is a Toronto-based lawyer, patent agent, and trademark agent. And Anil works with all types of intellectual property law, primarily focusing on patent and trademark prosecution, technology licensing, industrial design protection, copyright, and various other forms of IT law matters. Anil, thank you so much for joining us today, and welcome to Product AMA.
Lee, thank you so much for having me. I really appreciate the invitation and appreciate speaking to the audience as well.
That's great, great. So let's start off with a little bit about you. You did a degree, as I understand, in computer engineering prior to studying law. So tell us a little bit about why you were interested in law after engineering and what led you into intellectual property law specifically.
So I think that my story is probably similar to how a lot of product managers are introduced to IP law, which is through a potential litigation. When I finished computer engineering, which is about 18 years ago, I worked at a medical device startup here in the GTA. And we were pre-launch, so we were working on a handheld medical device. And we were pretty close to launching. So we had Health Canada approvals, FDA approvals, ISO certifications. We had the whole thing ready to go. We were probably a couple of months away from launching a product in the market. And lo and behold, we were threatened with litigation from a Texas-based patent holder. And I had no idea what intellectual property was about. I didn't know what patents were about. It was my first introduction in any way to the law. And I vividly remember reading that patent and thinking, we are in big trouble here, big trouble. Now, we had hired attorneys, IP attorneys here in Toronto to represent us. They came in for a meeting. I was lucky enough to be invited to that meeting. And they said, oh, this is baseless. Don't worry about it. This is just trying to keep you off the market. Nothing could have intrigued me more than the difference in my view from a technical perspective and the attorney's view from a legal perspective. And I got to spend some time with them. I became the liaison to our attorneys from a technical perspective. And I just thought their job was really interesting. They get to see a lot of technology at a high level. They don't need to deep dive and become intimately familiar with code necessarily. So, their job becomes broad. They get to see a lot of technology before it hits the market. And to me, that was really attractive. I'm a nerd at heart. And so I thought, you know what, this is the career I want to be in. And so from there, I took the LSAT, went to law school, and here I am today, 18 years later.
Wow, wow. Did you consider other sort of aspects of law, or was that the original driver was IP law because of your experience?
It was IP all the way.
Okay.
When I came up through the post-law school profession, so you have to article for a year. I did article at a general corporate commercial, quite a large firm, and they put you through rotations, which is very good for learning various aspects of law. I think I was quite single-minded in wanting to be an IP lawyer, maybe to the detriment of some of those other skills, but I knew what I wanted to do. I'm happy I did it. And, dealing with tech companies primarily, as well as product companies and, like hard goods companies, I think they can appreciate that as an engineering background and knowing the technology, knowing the innovations, it was just a very good fit for me. So,
absolutely.
Perhaps I could have tried litigation a bit more, but I'm happy where I am.
Yeah, well, and your clients know they're in good hands because you understand a lot of the underlying technology too.
I like to hope so. Yeah.
That's cool. That's cool. So let's talk about product management, and I think it's a little unusual to be talking about intellectual property law because I think most product managers either haven't really run into it or thought about it, or like you, they start thinking about it when there's a threat of some sort of litigation, right?
Right.
And they start working with someone like you. So from your experience, when is it important for product managers to start thinking about IP or intellectual property? And what are some of the first questions they should be asking themselves or someone like you?
Yeah, great question. I guess the first time to think about it might be when there's a threat of litigation, right? If you haven't thought about it before, that is a time to think about it. There's no doubt. I recommend approaching IP from a more proactive rather than reactive position. Companies that are leveraging IP successfully, they tend to be the ones that protect IP reflecting business value. So they're always seeking out the business aspect, the marketing aspect, the reason that customers come to the product. And when you look at those reasons, you can sometimes correlate those to patentable or other IP-centric issues. And so these companies that are successful tend to be the ones that are clearing their products from infringement or protecting their innovative technology. Now, if the first time you think about IP is when you're threatened, then you're too late, frankly, right? You might have had significant infringement liability to deal with. Furthermore, you might have a very little leverage to negotiate. So if you have some IP that's already kind of shored up and maybe protected, or that others perceive as valuable, that gives you leverage to negotiate a settlement if you're in the wrong. Now, in terms of product managers specifically, they're in a unique position to proactively assess IP from a protection and risk perspective. I think specifically because they're interfacing with every other function on a constant basis. And so you're getting the sales and marketing side, you're getting the business benefits, you're getting the technical hurdles that the engineering team may have faced. And being able to look at all of these facets of the development cycle and make connections between technical hurdles and overcoming those hurdles with where the business value is, that's basically what IP protection is all about. And so these are the people who are essentially positioned to really be the leads on the IP strategy side.
Interesting. I guess in some ways it's a little bit like being a product manager in a regulated industry where there are certain sort of constraints on what you can do or can't do, right? And so the IP perspective is useful to help that. But yeah, we'll come back around to that in a moment. But welcome to everybody that's participating in the product AMA today. We're talking to Anil Bhole, who's a intellectual property lawyer. And if you have questions, please ask them in the Zoom chat. We will get to them shortly. So Anil, you've done IP work in a pretty wide range of technologies. It sounds like machine learning, neural networks, image processing, semiconductors, even hard goods, including consumer goods. Can you give us some examples from your experience of what you've seen happen when there is no or insufficient IP protection?
Sure, yeah, I'm happy to hear some stories. In my own experience, actually the lack of protection, it's seen much more quickly on the branding side. So when we talk about IP, and I think especially amongst product people, it becomes a patent conversation to the detriment of other types of IP. Other types of IP would include trademarks, design rights, and even know-how. So we've seen this happen on numerous of our clients with trademarks. And a very particular scenario would be we represent a Canadian tech company. I say tech because it's often that you start in your home location and then you have very rapid growth worldwide. So we have a Toronto tech company that's a client. We've protected their trademarks in Canada, maybe the US. That's quite common. But lo and behold, a European competitor springs up. Very similar branding, very similar name, similar products. And there's actually nothing really stopping that third party from doing that. And so we see the lack of protection jurisdictionally and multinationally as a huge problem. And I say problem because there's a big cost constraint in being proactive in that sense, right? Protecting a trademark in every country of the world is cost prohibitive for virtually any company. So knowing where your market might be and knowing where you care about containing your market, that's quite important. So this has happened to our clients. I would say I can think of 5 clients off the top of my head where we've had to negotiate with a European rights holder to get our branding back when really we don't have much leverage in that sense other than to pay the price. So had the clients proactively filed in Europe or China or India or wherever else that arises, that's useful. Now on the patent side, we have definitely seen some issues as well. What we've seen occur is that especially growing companies will fail to file a patent application for their inventive product before launching. It's quite well known, and I'm sure there are people who are not aware of this rule, and they shouldn't be. It's a legal rule. But I'll let you know now. It's quite well known that if you disclose an invention publicly, which could be releasing your product, then in most countries of the world, you can no longer file a valid patent application. It's essentially become public domain the minute you released it. So it is incumbent on you to have filed a patent application somewhere, whether it's Canada or the US is the 2 common places we would file first, the day before you launch your product. That is very important if you have an innovative product. Now, for either cost reasons or lack of knowledge reasons, which are, again, common, that may not have happened, and it hasn't happened for a lot of companies, especially, I would say, startups, right? Your early stage, all the money is going to marketing and development. You just don't have the resources to file a patent application. And I'm not going to lie, IP protection is not cheap. So in this case, the initial product, it becomes public domain. And if a third party decides, oh, I'll reverse engineer the product, figure out how it works, and I'm going to compete, there's really not much stopping that third party from doing so. So then what we find is that the company that's our client grows, they become successful, and the resources increase. So now we can at least pursue protection on inventive improvements. That is great, but doesn't change the fact that the underlying tech has become public domain. And so this has happened on countless occasions, not to our clients only, it's a worldwide truth. So what we're seeing now, and I think this is actually quite illustrative of policy moving forward, is that we have quite a few clients who either are in a space where technology becomes obsolete quite quickly. And so in general, worldwide, patent rights will last 20 years from filing. We have you mentioned this earlier, we have quite a few clients in the AI space, for example. AI technology does not have a 20-year shelf life, for sure, right? So in this case, do you spend 3 to 5 years pursuing your patent rights only to know that in 5 years that patent is of very little value? Maybe, actually. It might be underlying technology. But in a lot of cases, it's not. And getting out of tech, in this current climate we're in today, we've had a number of clients, off the top of my head, I can think of 3 or 4 of them, that have pivoted their business to address COVID solutions. Right? So one, for example, they do a testing device. One has pivoted from the auto industry into face masks, which is a common pivot. Now, in these cases, this is a product that is on the market now and may not even be on the market in 3 years. So many government patent offices, they will permit you to accelerate your examination. And so now our clients are accelerating. There's a cost to it, but it's worth it. And so the lack of protection in that sense would be that you have a huge market opportunity now. You could be the only player, and not protecting would diminish your commercializability by an order of magnitude. And that would be a shame for a pretty insignificant time and cost investment to get the thing done right.
Interesting. Yeah, I mean, that's interesting thought about the auto manufacturers pivoting to face masks, because I was under the impression that they're kind of using open source designs, and so they're not necessarily doing something innovative. But if they were, then obviously that would be important.
Yeah. I think that's true. I think it's not a unique story pivoting into the face mask or face shield industry. Mm-hmm. And there are some solutions that are out there in public domain. There's other solutions where they're solving problems with the public domain face masks. Maybe they fog up too much. Maybe they're not shatter resistant. There could be issues. And then overcoming those issues, you might get a better product, a patentable product. And that's not to stop people from making it. Maybe you just want to corner the market on the government procurement, right? Mm-hmm. So there are some good reasons why there's still innovation happening in those spaces.
Sure. That's cool. Yeah, in fact, we've got a question from Jeff here, which I think you've sort of answered. At what point in the company life cycle would you recommend thinking seriously about IP? And so, there's, as you mentioned, early on as possible makes sense. Yeah. But what are those sort of questions, back to the kind of questions that a product manager, first product manager at a startup company might, sort of ask themselves, when should we be thinking about this, right?
Yeah, it's a great question. So you're right. I said as early as possible. That's a very easy answer to give because it doesn't give you an answer, right? It's a way up for me to not give you an answer. If I'm giving you a more definitive answer, it's at least 2 months before you launch your product or service. And that's because that's the minimum amount of time you'd have to engage someone like me to help you protect it. Now, at least 2 months means do it earlier, but definitely not less than that. When you're in a industry, so it actually goes back to wondering what industry the company is in, right? The industry might be slow moving, it might be very legacy innovation based, or it might be a super cutting edge, first ever in that field company. Now, depending which one of those two companies we're talking about, I think the timeline really differs, right? If the company knows that what it has created has just not existed before, IP is central to that company. Right, and I think the consideration of how IP protection fits into the company generally is going to be an earlier question. Now, if you're in a very slow-moving beast of an industry, and the innovation you've made is, frankly, relatively minor, protecting that IP may be of negligible value to you. So there's a lot of context involved in there. Now, the other aspect is, I think, and going back to what I mentioned earlier about the role of the product manager and liaising with the other representatives of the team, I think it's not necessarily the case that there's a time that is important for the product manager. I think what's more important actually might be the cues of when to think about, oh, this brings forward an IP question. And those cues to me there's really two main ones. And I kind of alluded to them earlier, where one is that your company, which has competitors in the industry, realizes there's an untapped market with a not massive pivot to your product line, right? So you can take your existing product line, you can attack a whole new vertical by making a tweak. And now if nobody's done that, presumably there's a reason. And determining what the reason is and how you solve that problem could be the prompt of the conversation. The other is looking at the same scenario, but from the other angle, which is you deal with your engineering team. The engineers are saying to you, we're behind schedule. We don't know how to create this particular feature because there's a problem in the known state of the art. A week later, they come back to you and they say, oh, we fixed this problem. Or you yourself have fixed the problem, right? And if you yourself have fixed that problem, which was a known issue, that itself could be a patentable solution. And so it's these two cues. Where is the business value? And does that business value require innovation? That's one cue. Or was there a technical problem and we solved it with a technical solution? That's the second cue. And so as soon as you face that to me is the prompt to consult someone like me or consult your internal IP coordinator if you have one.
Right. Wow. And that sort of leads me to another question that's related, and that's that, obviously in more lean, methodologies and agile development environments, stuff is kind of getting released all the time, right? And being tested and experimented. So you actually almost sometimes don't know whether it's going to work until you've released it.
Sure.
How do you deal with that kind of stuff, given that you said if you've released it, it's too late?
Yeah, I mean, we can't solve every problem, I guess. That might be part of the answer. But I think if I'm abstracting, and I'm sure I'm not addressing every scenario, I may be addressing a minority of scenarios here. But solutions which are implemented in the time of a couple of days or a week and then released and tested, again, I'm abstracting. I don't want to diminish what people are doing out there in the field, but it's likely those aren't the key movers of the business and of the sector, right? The stuff that moves the sector is, and sorry, before I go on, those minor improvements still could be patentable and still could have a lot of value. So I don't want to neglect those. But in the common environment, I would say the times that you're going to be engaging your patent counsel specifically will be on the more significant releases, right? You're planning this thing 2 months ahead. You may not even know how you're going to get there. And maybe the detail of implementation is still a bit lacking. But the generic implementation is known. And that's when you can engage people like us. As long as you know generally how this thing's going to work. You might not know all the parameters. You might not know all the optimizations. That's probably okay to start the conversation and even maybe to get to the end. Mm-hmm. Now, in terms of agile development, it also brings up, and I'm going to be speaking to software specifically in this case, which, I mean, agile can apply to non-software innovations as well. But on the software side, if you are a company that develops a cloud-hosted platform, you may not have the same problems, because when you do release code on your platform that no one can get at, they only see the UI of it, you may not have the same disclosure problems and making things public domain. It's a fact-specific scenario, but there is a difference between releasing a piece of software that is installed on someone's computer on a client side and releasing software that's installed on server side where no one can really access it legally.
And even if clients don't have access to the source code, on a platform.
Yeah.
Wow.
Yeah,
okay.
Even so. So I don't want to give a definitive yes no, but generally speaking, if you have object code on the client side, and it can be argued that one could reverse engineer the way the object code is working, maybe not picking up the exact source code, but understanding algorithmically what's going on, then that's a disclosure. it doesn't have to be right out in front of the guy's face. It's if they can reasonably figure it out, given technical skill in that space, that's a disclosure. So, and again, I mean, there's going to be fact-specific scenarios for everything, and there's no hard and fast rule, but I'm willing to say that that's a generally accepted principle.
Cool, cool. So let's talk about the other side of that last question, which is about the benefits of intellectual property protection. Is it primarily about risk mitigation, as we've been talking about, or are there other kind of business benefits that product management should be thinking about?
Yeah, so in terms of risk mitigation, I mean, I assume you're talking about infringement risk. I mean, everything lawyers do is risk mitigation, so we can always couch it in those terms. But I think that is still the leading driver of why a majority of companies and clients are pursuing patents, is to mitigate the risk of infringement. But it's by no means the only one. And there are significant other reasons that even our clients will come to us. We have a particular client, very successful company in the software space, the leader in their industry. It's still an emerging industry, but they're one of the leaders for sure. It's an AI-based company. And they will really be filing patents before every round of financing. It is an asset-based decision. And in some of these situations, even our guidance might be, this will be a very hard patent to obtain. But that's okay for the company. The company's goals are to create assets on the ledger in that case. And we're not doing it willy-nilly. We're still picking the ones that are the best candidates. So I think that's a very significant reason that many companies will pursue a large patent portfolio, is to have the number of assets high. There's actually been a couple of really interesting studies over the years. The ones that are most prominent to me they're a bit dated, about 8 years old now, but out of MIT Sloan Business School and out of Berkeley Business School, there were 2 studies. So one actually just looked at raw numbers. What is the likelihood of getting venture-backed financing across various industries if you have no patents or if you have a significant patent portfolio? And in every industry, it was higher if you had more patents. And I'm not a huge fan of, I mean, it's good for my business to say that, but I'm not a huge fan of just doing that. Now, on the other hand, in the MIT Sloan study, which is, I think, for 2010 or 2008 at this point, it's a bit old, but they looked more at qualitative metrics. So what they were looking at was, and they're looking at early stage companies, did that early stage company put their mind to a good strategy? Did they really think about what they're doing? Did their IP portfolio reflect what they wanted to do? And had they looked at third-party IP risk? All of these things. And then they tracked these companies and to the outcome. The outcome is either they folded, they went public, or they were acquired. And I can telegraph where I'm going with this, but the ones that had higher scores on the IP strategy component just did better. The ones with the highest score went public, which may not be attractive these days, but it was back then. And the ones with the next highest scores, they were acquired. And the ones that were very low score were, by and large, didn't go anywhere. So I think those are 2. Beyond those, marketing actually is another one. If you file patents on key technologies, you can market it as patent pending. That's good for marketing to your customer. It's also good for an implicit threat to potential competition, right? If the potential competition either can't access your patent applications, which is true for the first a year and a half that you file, or they're just not sophisticated enough to know what to look for, they just might be scared enough not to enter the market. That's a huge benefit, right? A huge benefit. The other one would be to, fend off other competition in ancillary industries, right? So you might say, we are patent pending for water treatment solutions, when in reality, you're a water treatment solution that only applies to power plants. Now, this might kind of telegraph where your next vertical is going to be. And the players in that industry actually might be kind of scared because you're going to upend their long-standing legacy monopoly. Those are valuable things sometimes. So the final one that is quite prevalent as well is in terms of collateralization. So this is quite true, especially with, we see this a lot in service industries with branding. They're going to protect their trademarks. They'll put those trademark registrations up to get a loan. That's quite a common way to securitize your loans. Because if you're a restaurant, for example, the whole value of your business is the name, right? So these things are important too. So there's many key reasons, but the risk mitigation It is the top one.
Key one for sure. Yeah, I mean, you think back on, companies like IBM who, because they were doing research and had research labs, there was a huge amount of patent activity going on there, right? For many, many years. But in the end, that probably was one of their biggest assets, right?
Absolutely.
Was that. So
yeah, for many years, IBM has been the most prolific filer in the US Patent Office. They've been overtaken recently by some Chinese and Korean companies, but they're still, a large filer. I will say, from the perspective of the large company, they may have other alternative reasons that they're filing quite broadly. One of which may be to create a cross-licensing pool for mitigating potential infringements of other people's IP, right? If you're an IBM going up another large blue chip company and each one is infringing each other's IP, they might both let it go because they both have valuable portfolios. And so having a large amount of patents, or maybe not a large amount, but a good amount of valuable patents to put up against a third party who also has patents, that's a good way for both parties to move forward and not kill each other.
Interesting negotiating strategy, yeah, for sure. And how, I mean, we don't have to go too much detail on this, but how do they go about sort of assessing the asset value of those patents?
Yeah, that's interesting, because there isn't one key way, but actually there are three different key ways that valuation occurs. And I'm certainly no valuation expert, but depending on the stage of your company, one of the three ways normally applies. So if you're a pre-launch or early company in your space, quite often the valuation method that is used is I'm not sure what the technical term, but basically how much would it cost to replicate what you've done? How much did you spend, right? And that's the value of your IP. Now, when you get larger and the market is proven a little bit more, then you can assess the IP versus what the market is paying for the technology, with consideration of how much of the product correlates to the IP protected in that product, right? And then the third one actually is based on market, right? It's if somebody has bid for a competitor in your space who has a certain portfolio that is somehow reflected in some factor to yours, you can then infer the value of your IP from there.
Interesting. Cool. Hey, to the participants, keep your questions coming. They're great. And I'm going to turn to a few of them now for Anil. Jeff wants to know if you see differences in the approaches to intellectual property law between Canadian and US firms or startups or otherwise. So, I mean, yeah, the US Patent Office is kind of the primary one, but what other kinds of differences might there be, or have you seen?
So I will say that, and that's going to be sector specific, certainly. But from my experience, US firms file way more patents than Canadian firms. I think it's correlated to the financing that those US companies are able to obtain, right? I think it's a well-known historical fact, or maybe it's an anecdote, but I believe it's a fact, that the ability to raise money in the US is much higher. And then correspondingly, the ability to spend that money on proper protection is available to you. So, there's a correlation there. In terms of the approach to filing, I'm not sure there's a huge difference between the US and Canada, other than the number of them. But also the partnerships are different, right? I like to say that IP doesn't stand in a vacuum. IP really only can be valuable if it reflects the business. Otherwise, IP is a piece of paper, right? It's an intangible property that doesn't really exist other than on the piece of paper we write it on. And so if there's no business backing what is claimed in that piece of paper, the paper has no value. So if we're looking at a US company that has a lot of business opportunities just in the nature of the business environment down there, then the value of their IP is going to go up. They'll spend more to protect various aspects of a particular product. On the other hand, in Canada, what we tend to see is that from a large company perspective, I think they're already there. They get it. They protect basically every innovation that they have that has any likelihood of becoming valuable down the road. They're willing to take a bit of a risk to spend the budget up front in case there's some value down the road, but they have that budget to spend. Now, when you look at the early stage companies, it's harder for Canadian companies to get sufficient financing to take that same approach as they would in the US, I think, by and large. And so we tend to find that they will do a first patent application, for the foundational aspect of the technology and just try to ride that wave for 2 or 3 years. That's quite common. The same company in the US would not have done that, I think. Now, on the other hand, we have, so in our practice specifically, we represent quite a number of universities here in Canada. And I would say they have a different approach, right? Because they are not necessarily mandated with turning a profit on their IP. The mandate there is to really protect good IP for either licensing out to third parties, which don't need to be Canadian, or for generating spin-offs, which don't need to be profitable right away, right? It's not a shareholder issue, basically. And so in that case, if it's a university spin-off, we do tend to find that they're more likely to file wisely on more than one foundational aspect.
Interesting. Yeah, I guess. Yeah, and they're certainly looking at, in the case of the institutions that are working with Mars, for example, the whole mission there is to commercialize research and science technology in Ontario, right? So of course that would be a part of it. Yeah,
exactly.
I understand. Cool. Another interesting question here from Jaya, who's asking, if you have a solution that is potentially patentable, how much information is sufficient to make a submission?
That's a great question. That's a fantastic question. That's a question I'm glad has been asked. And it's actually the same question as it's a similar correlated question to when would you engage someone like us, right? So the requirement for a patent application is that you need enabling disclosure. So then the question becomes, what is enabling disclosure? And the way I like to speak to or advise my clients how to give me that is, I want you to teach your closest competitor how to copy you. So in terms of level of detail, you probably don't have to go and explain the code, because if you tell them what the function is, they would probably figure out how to code it, right? So algorithmically, we want to know how the invention would work. How can you actually take this writing as an instruction manual, give it to your competitor, and they would be able to replicate what you've done. And that is the sufficient amount. So when we roll this back into where in the product lifecycle do you engage counsel and possibly file a patent application, it is when you know enough that you could explain it to your patent counsel, this is how it's going to work. And there might, again, be optimizations and parameters that are not known, but getting it to work, would still happen. It just might not be the best, right? Now, in some countries, there actually is a best mode. You have to give them the best way, but that's by and large been abolished. So as long as you can instruct someone who has skill, they're in your space, how to do what you did, that's what we need.
Interesting. That's great. That's very helpful. Jeff has another question about patent pools. What's your view of patent pools, and what value do you think they may be able to bring to Canadian tech companies?
Okay, this is a great question. I was going to touch on patent pools on the last question, actually, which I neglected to do. You asked about what are some of the other reasons that companies might want to protect IP. One of them is to enter into a patent pool, and a similar, which I'll speak about. Another reason, which is connected, is to actually help monetize their platform and get third parties onto their platform. And I think they're connected conversations. So in terms of patent pools, there are various forms of these patent pools. One is a private consortium. So you'd have X number of companies all agreeing to put their patents together as a pool and cross-license as much as they each need, which again goes to the large company, the blue chips having large portfolios and just not wanting to litigate, because litigation is usually not good for any of the parties. It's a sunken cost. And so this gets them around that issue. But when we look at other forms, so there is the open, I guess you can call it, for lack of a better term, the open sourcing of your patents. A well-known example, like Tesla did this a while back. They took all their patents, they said, we're releasing all these patents. And now, not speaking to Tesla specifically, but sometimes when companies do that, it is not for philanthropic reasons. It's not to enable others necessarily to all get into this space. It's actually to monetize their platform, right? And they want to get third parties onto their platform and onto their protocol. But the only way to get them on is by allowing them to copy all this other stuff. The protocol patent itself, or the platform patent itself, may never have been released. And that might be the thing they need to make sure that all the third parties are tied to their ecosystem. So that's another reason. So
that's not just licensing, but that's more just kind of establishing a de facto standard.
Yeah, it's just saying, hey, this is our patent. You can just use it. No payment, nothing, no tit for tat, no quid pro quo, right? The quid pro quo is that in order to use it, your product's going to end up being on our platform anyways. That's the quid pro quo. Now, in terms of the question, I'm not sure I answered the question directly, to be honest, but for patent pools, they make sense if each of the holders has assets to provide, right? And getting to that point is where the difficulty is, and knowing why you'd want to enter it, right? You must understand that you lack IP that the others might have, and then there's a reason to give up something to get something.
So not likely an advantage to an early stage startup, but potentially for a growth stage company that has a patent or some patents, but then wants to be able to trade on that and expand their access.
Yeah, I guess actually depending on what you need and what you have, it might be if you as a startup, an early stage company can get into a patent pool, that might be a great place to be, because you're going to get access to a lot more than you're giving access to, right? You're going to profit off the access. Being a large company, essentially donating to all the small guys, that's not a really attractive place to be. So again, but it all goes back to, and the small guy might have the one great patent. That's possible. It all goes back to what the rights are and what you're willing to give and willing to get.
Interesting. So Paris is asking an interesting question here about consultants who may engage clients in technical solutioning. How can the consultant protect the IP for new innovations developed during that engagement from being owned by the client? And he goes on to say the development of something new is not by design, but the opportunity may come up as a result of the client engagement. Does that make sense?
Yeah, it does. So that's a very fact-specific question. I mean, so they all are. But in this case, it all goes back to whatever the agreement was under which the contractor joined the company, right? So commonly, the consultant will be subject to a written agreement. The agreement is, if the consultant is being brought on in a development type role to develop IP, it would be abnormal that the contract would not speak to that IP. And in a typical independent contractor agreement, the client company would be the owner of that IP. It would be unusual to go any other way. Now, in the specific question that was asked, it seems like the developed IP was not central to the role, in which case the question would become, firstly, was the consultant even brought on to develop IP at all? Or did they develop IP to accomplish the thing they were supposed to do? And then we go to secondary factors. So some secondary factors would be, in the development of the IP, was that done on the premises of the client or on the consultant's own premises? Did they use the client's computer to do it? Did they do it on their own? Was it during business hours or off hours? What were the expectations of the companies going in? Did the client believe that anything the consultant was to create would belong to it? These are all relevant questions to resolve that issue. So but I'll go back, if the consultant was brought on specifically to help innovate and help design new IP, it would stand to reason that the client will end up owning it.
For sure. Yeah, no, that makes sense. And in my experience, that's been, whatever is developed in the engagement is proprietary to the client or becomes the client's. Unless, I guess, occasionally, consultants have their own patentable or patented, tools or frameworks or things like that. And in those cases, obviously, that would be defined up front before going into the engagement, that each party would maintain its own ownership of whatever it's using, right?
Yeah. Great point, Lee. Great point. So you'll see quite commonly in these consulting agreements, or even joint venture agreements, or any kind of two-party collaborations, there'll be a definition usually referred to as background IP. And background IP speaks to exactly what you mentioned, which is, I'm going to bring this to the table. It already exists. And we're going to document this in the schedule to the agreement that I already made this. It's not part of what we're doing going forward, but yeah, I might use it. Now, I have seen with our clients, I can think of one specifically where they were brought on to develop. So I'll come up with a tangential application that's kind of similar. Let's say they were brought on to develop a website, and in the development of this website, they decided to build a really novel database, and they had pre-agreed with the client company that everything we give you, we're going to give you the website, but the underlying technology, we're just going to perpetually license it to you. So you'll always have free access to it, but we're going to own the framework. We're going to own the bones. And the two companies agreed. And technically and commonly, as long as two parties agree to something, unless it's really egregious, no court is going to say, oh, that's not valid, right? So if the companies agree that a consultant can own everything, that's generally fine. It's all about the agreement. So that's a unique situation. You can overcome those default scenarios with an agreement.
Yeah, yeah. And you actually see that a lot with, professional services companies that move into product and become product companies that, that they have, they have built code, products, whatever you call it, applications to support the work they're doing in multiple different clients. It's reusable code, object-oriented, whatever. So it's actually not an uncommon thing. But yeah, separating those two up front in the agreement, which is most of the case in any kind of legal arrangements, right? It's getting clear at the beginning. Yeah, that's great. Keep the questions coming, everybody. They're great. Really interesting stuff. Let's see, what's the next one we have here? Just sort of leading off of that, when product managers think about IP for their products, should they be thinking about processes and services as well, or is that completely separate?
So processes and services can be patentable depending on what they do and what they are. Without giving a definitive yeses and nos again, generally speaking, a business process and even an automation of that business process, it's going to be hard or impossible to get a patent on that. And that still might be good IP because you could still frame it as know-how. And if it's complex and it requires some instruction, that could still be something that you embody in a manual or an instruction guide or a policy, but it's not probably going to be a patent. But there are processes and methods which become patentable, and those are the ones that are technologically grounded. So if you are solving a technological hurdle by a technological process, that's still patentable. Quite often we hear from prospective clients, and we don't hear this from our clients because they've gone through this before, but prospective clients will sometimes come to us and say, oh, we do a bunch of software stuff. We know that's not patentable. Here's some hardware stuff we do. Now that's actually a myth. It's not that software is not patentable. It's that simple software is not patentable. And by simple software, what I mean is automating a process that otherwise could quite easily be done by a person, right? So you have a rules-based system for calculating 2 + 2, and you want to put that into code. There's no way you're getting a patent on that. The process itself already existed. You're just putting a generic computer around it. But a process for encrypting data, which is only going to happen really in software, and I guess you could do it with a calculator, but you're not going to. That encryption is a huge amount of patents. There are thousands and thousands of patents on encryption. There are thousands and thousands of patents on bandwidth allocation. There are thousands of patents on load balancing. There are thousands of patents on many types of things that you could call a method or call a process that are not just a hard product. And those things are all patentable without question. The patent office is not pushing back on those patents, and courts are not invalidating those patents.
Interesting.
Yeah.
Well, that adds to the complexity, of course, but it's good knowledge going into it. So Angeli is asking that in their experience, they've applied for patents based on draft manuscripts for paper submissions in non-academia cases. What format does the documentation that's brought to you typically resemble?
That's actually a really interesting question because, sorry, my dog walked in. That's a great question because we do deal with several universities, and we receive a lot of manuscripts for the patent write-ups, for the disclosures to us. So the first thing I will say is that a manuscript is probably the best disclosure to me that I can receive. Because as we go back to the prior question that was asked about what kind of detail do we need to file a patent, the manuscript is the detail. It's going to tell you the same story that a patent's going to tell you, which is, how do you do what we did? That's what the manuscript usually gives you. So when we receive these, I'm not sure what the question meant by format, but I'll just tell you the basic answer is that we'll receive them in a latex format and we convert it to Word. We do all our work in Word, right? But we have a converter for that. Now, in terms of, and going to a different answer of what kind of format do we receive our disclosures in? Yeah, manuscripts, again, are fantastic. It brings up a different question for me, which I want to address, and goes back to one of the first things I said on our discussion here today, which is that disclosures to the public can violate any patent right you might get one day. Now, I'm actually dealing with this issue with one of the university clients we have, that it's quite common for us and most universities to consider the publication date as the must file patent date, right? So the submission date to a particular journal for a particular conference might be months ahead of that, but we use the further date along, which is not a safe way to act, actually. It's safer to use the earlier date, but sometimes we don't have luxury. We are engaged after the submission has been made. So if that happens, and I know I'm not answering the question that was asked at this point, in those situations, if a particular individual has a scenario where they can engage counsel before submission, you should do that. If that's already happened, it's quite important to determine what the conditions around the submission were. So most of the more sophisticated journals at this point, they've put confidentiality language around the submission process and the review process. So reviewers are required to agree to confidentiality in order to become a reviewer. And I mean, part of the reason for this is not divulging it to the third parties, but another reason is that they want to maintain patentability for the good ones, right? Once you're accepted, you know you have legs in this technology, you file your patent, you don't want to have known that too late. And so, again, this is a non-academic manuscript, but you want to know when it's going to publish and beat that date.
Mm-hmm. Right, right. Yeah, I mean, the sort of determining factor is when it's publicly available, right? So if it's controlled, you know, in an environment like the editorials, where there's confidentiality maintained, then yeah, maybe that's more defensible. I can see that. Yeah. Okay. Cool.
Well, I'll just add. Sorry, I'll add one more point there. So we use the word public disclosure, and we've had some. I actually had a call this morning where this came up. The word public in public disclosure does not mean the general public. It means any person outside of a confidential relationship. So if I share my technology with one person, but that person had no obligation of confidentiality, that is a public disclosure. And so submission to a journal that is not covered by disclosure rules or confidentiality rules, rather, even if only 2 people are reviewing it and 2 people see it, it's still publicly disclosed. And so just to clarify that point.
Yeah, no, that's good. Helpful, very helpful. Thanks. So we have time for a couple more questions. One is more about the career, which we talked about your journey at the very beginning. But Faze is asking that for product or tech individuals looking to make a move towards IP law, beyond industry knowledge, what are some of the skills you think are essential for a smooth transition?
I love that. I love that question. I love that question because I just spoke about that last week on a career panel. Okay. I think depending on how you want to conduct your practice, there are different skills that are required. So I'll speak a little bit to what our industry looks like. And I guess I'm kind of speaking towards the patent part of it, because there are also trademark attorneys who tend to have different personalities. Patent attorneys, I'm really generalizing here, so don't hold my feet to the fire too much, but patent attorneys by and large are introverts. They're happy to be at their desk. They're happy to pore over the technology and really get a kick out of the technology. Trademark attorneys tend to be extroverts who are out in the consumer space potentially, or they're a bit more enthusiastic. They're on Twitter. They're doing all like the outreach. So depending on what kind of person you are, you may want to go one way or another. Now within the patent space, there are many personalities. So we're on the agency side, which means we draft the applications, get them through the patent office, and that's kind of our role. We also do licensing, so we do the agreements to surround the IP. But another aspect is the litigation people, right? And so if you're an IP litigator, you need to be a research-oriented person. So really digging deep into, I wouldn't say the minutia necessarily, the granular details of or granular issues in the law, and being able to research these things for hours on end and come up with reasoned arguments, that's a tough skill. On our side, I actually think the greatest skill that we have, that we need to do our job, is listening. You really got to be able to listen to your client. And I don't think we're unique in that sense. I think product managers fall probably into that as well. You need to listen to the client because, first of all, the client's the only one that knows the IP, right? By definition, if it's patentable, it's an invention. So it didn't exist before this person thought of it. And so you have to be patient, listen, be willing to admit you don't get it, and that you need more explanation, and then be able to translate technology to plain English. These are all skills that I think are kind of vital to the role. Now, if you want to be again, in this patent space, but be facing the client, that's actually a different skill set than on the patent space and writing the patents. The people who write the patents, they spend 40 hours writing one patent, and they just want to get it perfect, every word perfect. Whereas someone who's like me, I'm more client facing. I just love different technology. I want to understand at a high level. Oh, that's cool, and that's also cool, and I want to learn about all three, but I don't want to write the patent, right? So it's a great question. I think there's a lot of different personalities that can fit into this space. If you want to message that particular person who asked the question, I'm happy to have a conversation offline and get into it.
Cool. So let's see what other. I don't see any other questions that have come up per se, but talk for a moment about a product manager who's on a team that has licensed somebody else's patentable technology. Are there things that they need to be thinking about or aware of, or just following the rules? But are there kind of unforeseen hurdles that people should think about?
Yeah, it's going to depend on the agreement that the license was granted under. Quite commonly, when we're doing a IP license for patentable technology or patented technology, I would say the key consideration, there's two. One might be that you have a particular field of use, that you're allowed to attack a particular vertical with that technology and no other verticals. Another might be that if you do want to attack other verticals, you might have a non-exclusive or an exclusive license. So I think understanding the license terms is kind of the crucial thing. But the other aspect that I think is very important is understanding, based on the license terms, who's going to own improvements. Because quite commonly in a licensed IP situation, you might actually be the licensee might be the party doing all development. The licensor may be, for lack of a better term, not practicing in that space. They're a non-practicing entity. And so what you're licensing, actually, you might be the only ones who have the ability to make improvements. Now, commonly in a non-exclusive license, the company that is the owner would get improvements. And in an exclusive deal, maybe it doesn't go the other, maybe it goes the other way. Maybe the licensee gets it. So you need to know that before you expend significant resources improving, right? If you're not going to own the improvement, it kind of stands to reason you want to spend the money to do it.
Right.
So I think that's probably the one key. But also, yeah, knowing limitations, like you said, anything you're not allowed to do, don't do it if you need that patent.
Great,
right?
great.
Now,
that's
outside
really
of patented IP, there's actually a licensing question or licensing issue that I think I should touch on outside of patented IP, and it pertains to open source software. And I'm not sure how many people on this call are on the software spaces versus other spaces, but this is a question that I don't think most people outside of IP law would have considered necessarily, but it's extremely common to use open source licenses for third-party IP in your software product. I don't know a company that does not use open source software. I don't know in the software space. But knowing which license applies to each one of those open source modules is vital. And the reason it's vital is that there are some good licenses and there are some really bad licenses. And good and bad from the licensee's perspective. And the reason some are bad is that, I'm using bad as a very hardline word, I shouldn't say that, but they're not good. They're just not favorable to the licensee. They can make it so that it appears that the license terms of the module would then apply to your own software. So, the fear, and I don't think this is a fear that's really been panned out yet, but the fear would be you use some open source software for a module that's not really that integral to your product, but the terms of that license say that any use of the software means that your software must be open source as well. And maybe that's not what you want to do. And so knowing which license applies to each one of the pieces of code that you bring in and how that affects you is quite crucial. And just to wrap that comment up, that's going to come up most commonly during a financing round, right? The investor is going to want to know, have you audited your code? And if you've audited it, what are all the licenses that you have? And do you have any risks here?
Right.
And it could affect valuation. And it has. We've been on deals where that's affected valuation. I've been on a deal where it killed the deal.
Wow.
So
yeah. Too much risk. Yeah.
Too much risk.
Okay. Yeah. We have a couple more minutes, but Jeff is asking, how much does it cost to file a patent roughly? Like, I'm sure there's a big range, but
there's a big range.
Yeah, but what?
Yeah, I'm still happy to give an answer. It'll be a range answer. Mm-hmm. So the complication of the question is that the factors are how complex is the invention, how high quality is the disclosure that the client gives to me, which means I do less work, but it's better. And then I think more significantly, where and how are you going to file the application? So one thing we didn't talk about on this call that I don't think it belongs in this call necessarily is what are all the strategic considerations into how and where to file your first patent? Because amongst almost all the countries of the world, most of the important countries, and frankly all the WTO countries, they're part of two key treaties that apply to patents. And under one treaty, you can apply for a patent application in one country and do all the other countries 12 months later. So it gives you a year to bide your time, raise some money, figure out where the market is, and understand where to file later. And you can do 12 months later, you can file it. And all those later filings essentially they're treated as if they were filed earlier by a year. So that's a key treaty. The other key treaty, it's that you can file an application internationally. So you file it in one patent office, so for us, Canada, but it has an effect that it gives you a filing date around the globe, essentially. And 2.5 years after that, you can decide to actually pursue those applications elsewhere. So I could file in Canada today, and 2.5 years from today decide, oh, I want to go into Europe as well. Outside of these two agreements, you actually don't have that right, because your filing here is probably linked to a launch here, and that launch here will violate your disclosure problem in Europe otherwise, right? Mm-hmm. And so knowing which one of these strategies you want to use is going to determine government fees, frankly, which can vary hugely. So now actually answering the question, if we break it up between, kind of our fees versus government fees, you're probably going to end up spending anywhere from $5,000 to $15,000 drafting an application. So that's our fee, right? Depending, again, how complex it is, how well your written disclosure is, frankly, how long is the document going to be? It's a time cost. Now, once you've spent that cost, that's the upfront day zero cost of filing the application. You still have the government fee. So a government fee could be as low as $200 for a US provisional patent application, $400 for a Canadian patent application, or we spend somewhere in the range of 7,000 euros to file in Europe. So massive differences across the board.
Yeah,
but
and I'm sure it can go into the millions too. Yeah.
Yeah. Well, so when you start getting the higher cost is actually after the filing, right? Because then you have to actually prosecute the application, which means you essentially negotiate with an examiner in each one of these patent offices worldwide what rights they're going to give you. And again, very hard to say as an answer, but I tend to use the general guidance that lifetime costs for each patent in each country is $20,000 to $30,000. So if you have one patent family in Canada, US, Europe, and China, that's probably getting into the six figures. If you have 1,000 patents, you're spending millions of dollars for sure. Oh, yeah. Many millions of dollars.
Wow.
But you would only do this. You'd only do this if there was business value of doing so.
Yeah, of course. This has been great. We're almost out of time, and I'm sure that people might be interested in learning more. Can they connect with you on LinkedIn and you could give them guidance on where else to go or that sort of thing?
I'm so happy to do that. And actually, if I can give a quick plug, the way that we actually practice in our firm is that we are very happy to have these initial consultations and just have an off-the-cuff conversation with a prospective client. If they just want to give us a shout and say, I have this kind of cool technology or cool product, what do you think? That's a conversation we'd love to have. No obligation at all.
Anil, thank you so much for joining us today. It's been a pleasure to talk to you, and I look forward to seeing you in person sometime soon. Everyone, enjoy the rest of your day. Stay safe, and please be healthy.
Thank you, Lee. Really appreciate you having me today.
Okay.
Take care.
Follow Product AMA on Twitter and send us your topic suggestions. We look forward to seeing you soon.